Welcome to this explainer. Look, if you're running a business right here in Johnson County, you already know that keeping your supply chain running smoothly is literally everything. But, what happens when things go wrong with a vendor? Today, we're looking at exactly how you can navigate those messy supply chain disputes without losing control of your business, your relationships, or your bottom line.
So, picture this. You've got a massive local client order due, but a crucial shipment from your vendor is delayed. The tension is incredibly high. Your emails are suddenly going unanswered, and your local reputation is entirely on the line. It begs the question, how do you fix a broken supply chain without going absolutely broke in court? Think about it. How are you currently stuck in your own vendor conflicts?
Okay, let's dive into this. Because honestly, business disputes usually don't just start as massive legal battles out of nowhere. They almost always begin from simple miscommunications. We're talking unmet expectations, maybe a missed deadline that causes a breach of contract, disagreements on quality standards, or even just a simple lack of clarification on billing. But if these things aren't handled properly right out of the gate, they can spiral completely out of control. So here is our roadmap for navigating this today. 1. The cost of disputes. 2. Litigation versus mediation. 3. The mediation process. 4. Choosing the mediator. 5. Legal realities. And 6. Preparing for success. Let's get right to it.
Section 1. The cost of vendor disputes. These are the high-stakes pain points.
When a vendor disagreement throws a massive wrench into the gears, production obviously slows down, and this inevitably leads to low stock and unmet customer demands. But the fallout here does far more than just cost you immediate short-term revenue. It severely damages your local reputation in Johnson County, which hurts those foundational relationships you desperately need to keep your operations running smoothly over the long haul.
Section 2. Litigation versus mediation. Let's look at mediation as a strategic business tool.
There is a fundamental, almost philosophical difference here that is so important to understand. Litigation looks backward to assign fault and liability. It's entirely about finding out who's to blame for the past, which, let's be real, almost always destroys the relationship entirely. Mediation, on the other hand, well, it looks forward. It focuses on finding workable future solutions. It aims to actually preserve the partnership so both of your businesses can move on and thrive. Now, looking closely at the element of control, a really stark contrast emerges. In litigation, you're literally handing over your fate to a judge or a jury. It's formal, it's very public, and it is incredibly expensive. But in mediation, it's informal, it's private, and crucially, you and the other party control the outcome. You hold that final decision directly in your own hands.
And here is perhaps the biggest relief of the whole thing. One day. While litigation can drain tens of thousands of dollars and drag on for months, or honestly even years, most commercial mediations finish in a single day. Think about that. You get back to actually running your business instead of running to court.
All right, Section 3, the mediation process explained. Let's demystify these steps.
A typical session actually follows a very intentional life cycle. First up, the mediator's introduction sets the whole process and the ground rules. Then, opening remarks allow each side to speak entirely without interruption. And this is followed by a joint discussion to sort of explore the issues together. Next, things might break off into what's called a private caucus. And finally, negotiation, where a mutually acceptable solution is crafted.
So let's look a bit closer at that word caucus. It sounds like super heavy legal jargon, right? But it's actually your biggest advantage. A caucus is simply a private, totally confidential meeting between the mediator and each party. The mediator uses what's called shuttle diplomacy, basically going back and forth between the rooms. This ensures you have a safe, private space to speak honestly about your bottom line without the opposing party sitting right there interrupting you.
Section 4. Choosing the right mediator. This really is the key to your success.
You see, you aren't just looking for someone who knows a little bit about supply chains. Essential mediator skills include strict impartiality, really strong communication, and immense patience. Crucially, a great mediator acts as a reality tester for Johnson County businesses. They'll gently challenge those entrenched views, ask the really tough questions, and expertly guide both parties away from their battle lines and toward a common ground.
Moving on to Section 5, Legal Realities of Mediation. Let's talk about the Kansas rules.
So the absolutely crucial point here is this. While the mediation process itself feels very informal and conversational, the outcome is incredibly secure. Once both parties agree and actually sign that settlement paper, it immediately becomes a legally binding contract. It is fully enforceable by a Kansas court of law, which gives you total peace of mind at the end of the day.
Now, we also need to talk about privacy. Confidentiality is a core promise of mediation. Almost everything discussed stays entirely private, which protects your business reputation from public court records. However, common-sense legal limits do apply here. The mediator is required by law to break confidentiality in cases involving threats of future physical harm or child abuse. But outside of those extreme exceptions, what happens in the room stays in the room.
Section 6. Preparing for success. It's time to empower yourself.
Okay, so your preparation actually starts with knowing your BATNA. That stands for your best alternative to a negotiated agreement. Basically, what are the exact, specific steps you're going to take if you and the vendor do not settle during the mediation? Knowing your absolute best and worst choices outside of that room gives you incredible leverage, confidence, and real clarity during the actual negotiation.
Beyond just knowing your BATNA, you need to gather your arsenal. Compile all the important paperwork. We're talking invoices, emails, contracts, and define exactly what matters most to your business. But here is the most critical step by far. You have to bring the final decision maker. The person sitting in that room must have the actual authority to sign the deal right then and there. Actually, if they don't, the entire process just stalls out.
And once the talks begin, your communication style kind of has to transform. Try to use I statements to express your needs without attacking, and be sure to ask open-ended questions. Critically, try to uncover the underlying reasons behind a vendor's demand rather than just fighting the demand itself. This completely shifts the dynamic from a hostile battle into a truly collaborative problem-solving session.
Which leaves us with one final, really important question. Are you ready to take back control of your business disputes? Because you don't have to surrender your supply chain or your profits to an expensive, highly public courtroom battle. The power to craft a forward-looking, mutual agreement is literally in your hands. So the next time communication breaks down, just ask yourself, do you want to win an argument in the past, or do you want to win a thriving business in the future? Thanks so much for joining me for this explainer.